Hello, beautiful people, and welcome to the Service Dog channel. Have you ever wondered about legal battles that shaped the rights of people with disabilities and their service dogs? Today we're diving into one such case that has had a profound impact on the lives of countless individuals. The case is Perry Hopman versus Union Pacific Railroad. Mr. Hopman joined the Army in 1993. He originally served as an active duty service member and spent about a year and a half on active duty before joining the National Guard. In 2006, he deployed to Iraq, and while there, he discussed employment at Union Pacific with one of his fellow guardsmen. Hopman was told that it was a great place to work, so he decided to pursue a railroad career at Union Pacific when he returned from deployment. While still a member of the National Guard, Hopman accepted employment as a conductor. After another deployment to Kosovo, Hopman returned to the United States, was diagnosed with post-traumatic stress disorder, PTSD, in 2008. He had completed 2 military tours as a flight medic, and during one of those tours, he suffered a traumatic brain injury from falling 50 feet from a helicopter. Hopman lived with PTSD and migraine headaches. To manage his conditions, he relied on his loyal Rottweiler, a trained service dog named Atlas. Atlas was more than just a pet, he was a vital part of Hopman's life, providing psychiatric support, assistance with tasks, and alerting him to potential triggers of his conditions. But Hopman's journey with Atlas took an unexpected turn when Union Pacific refused to allow him to bring Atlas to work with them. The railroad argued that Atlas's presence posed a safety risk. This disagreement escalated into a legal battle that tested the boundaries of the Americans with Disabilities Act. Hopman claimed that Union Pacific's refusal to accommodate his service dog violated his rights under the ADA. The initial lawsuit began in 2014. Hopman alleged discrimination under the Americans with Disabilities Act. The ADA is a landmark civil rights law that prohibits discrimination against individuals with disabilities in all areas of public life, including employment, transportation, and public accommodations. Under the ADA, service dogs can be considered a reasonable accommodation, allowing individuals with disabilities to participate fully in society. Hopman fully admitted in court that he was capable of performing his essential job duties without having a service dog at work, but he argued that working without his service dog caused him to experience mental and psychological pain because of his PTSD. While his job performance was assessed to be good, Hopman asserted that he could perform better with his service dog by his side. Although he was currently able to perform his essential job functions, Hopman feared that his impairments would eventually lead to the inability to do his job. His service dog, Atlas, performed such tasks as grounding him during flashbacks or high anxiety levels, warning him of impending migraines, reminding him to take his medications, circling him in crowds to keep people from getting too close, blocking people from coming up from behind him, finding the nearest exit of the building, picking up and retrieving objects, and waking him from nightmares. Note that Hopman regularly traveled for overnight trips away from home with Union Pacific. Hopman argued that Atlas was crucial for his ability to manage his PTSD and migraines, enabling him to focus on his work and ensure the safety of the train and its passengers. Union Pacific countered that Atlas's presence could potentially distract Hopman or create a safety hazard. In the district court, Union Pacific made a motion for judgment as a matter of law. A judgment for a matter of law is a judgment entered during a jury trial, either before or after the verdict, when a party has been fully heard on the issue and the court finds that no reasonable jury could reach a different conclusion. That means they argued that whatever evidence exists for the opposite conclusion is not legally enough. Union Pacific's motion for judgment as a matter of law was denied, and the case went before a jury. The jury found that Hopman was discriminated against and awarded him $250,000 in compensatory damages. But that's not the end of the story, because Union Pacific would, of course, appeal the verdict. Central to the disagreement between Hopman and Union Pacific was a key definition. Let me explain the issue to you. The ADA regulations give the following definitions of reasonable accommodations. We're going to discuss the third one specifically. Number 1, modification or adjustments to a job application process. 2, modifications or adjustments to the work environment that enable an employee with a disability to perform the essential functions of that position. Note that Hopman never claimed he could not perform his essential job functions. Number 3, modifications or adjustments that enable a company's employee with a disability to enjoy equal benefits and privileges of employment as are enjoyed by its other similarly situated employees without disabilities. The meaning of this reasonable accommodation is what the whole case rests on. What are the benefits and privileges of employment? Hopman asserted that the right to work without the burden and pain of PTSD, which could be alleviated by having his service dog with him, was a benefit and privilege of employment that employees without disabilities enjoyed. The EEOC stated that equal benefits and privileges of employment include, but are not limited to, employer-sponsored training services, like credit unions, cafeterias, lounges, gymnasiums, auditoriums, and transportation, and parties or other social functions, like celebrating retirements, birthdays, and company outings. So the question was, does equal benefits and privileges of employment include the right to work without the burden and pain of PTSD, which could be alleviated by having his service dog with him? The first judge took into account the key phrase, not limited to, all the examples of the employer-sponsored events. Listen again. Equal benefits and privileges of employment include, but are not limited to, employer-sponsored training, services, and parties or other social functions. The judge applied that phrase liberally. The next judge held that company-sponsored training, services, and parties or other social functions did not include the right to work without the burden and pain of PTSD. There was no inequality or discrimination because the company was not giving service dogs to people who were not disabled. This doesn't make sense to me because theoretically, they could say the same thing about people who use wheelchairs. Hopman wasn't asking them to provide a service dog, simply to allow the service dog to accompany him. Anyhow, the judge concluded that there was insufficient evidence to support the jury's verdict and overturned the decision, ruling in favor of Union Pacific. Hopman appealed the decision, and the Eighth Circuit Court of Appeals affirmed the district court's ruling, finding that the ADA's requirement of reasonable accommodation is limited to accommodations that enable an employee to perform the essential functions of their position and accommodations that provide equal access to a program or service that is provided or sponsored by the employer and that is not directly job-related. Finally, the case was briefed to the Supreme Court in hopes that they would decide to review the case and make a ruling, but unfortunately, they decided not to take the case. So ultimately, Union Pacific won the case. Hopman never got to take his service dog to work, and he got no compensation for discrimination. The case might have ended differently if he had asserted that he could not perform his essential job duties without his service dog by his side, or if the judge had used a more liberal definition to the phrase, equal benefits and privileges of employment include but are not limited to. The decision was a setback for Hopman and a disappointment for many advocates for service dog rights. The case raised important questions about the extent to which employers must accommodate service dogs. By advocating for stronger protections, we can help ensure that individuals with service dogs have the same opportunities as everyone else. The fight for service dog rights is an ongoing battle, and it requires continued vigilance and action. Subscribe to the Service Dog channel for more important court rulings like this one. Check out my playlist while you do dishes, fold the laundry, work in the yard, or walk your dog.